Hi and welcome to this latest immigration law update video. I'm Adam Pipe and I'm a barrister specialising in immigration, asylum and human rights law. In these videos, I aim just to provide a quick summary of recent case law, statutory and policy developments. If you're interested in some more detailed training, do sign up to one of the courses I run through organisations such as the Solicitors Group, MBL seminars, and HJT training, and I regularly do for those guys update training courses on immigration law. In this video, we're going to look at a new country guidance decision looking at the risk to Christian converts from Iran. The decision is called PS brackets Christianity Risk Iran CG 2020 UKUT 46, and it's a decision of the 20th of February 2020, and it's a helpful country guidance decision. The analysis is contained at paragraphs 117 to 140 of the decision, and the country guidance is at paragraphs 141 to 144. And let's have a quick look through the head note of that decision. The first thing it says is this country guidance applies to protection claims from Iranians who claim to have converted from Islam to Christianity. So it's looking at conversion cases rather than those who are ethnic Christians. And it says at paragraph 2 of the head note that in relation to non-ethnic Christians, this decision replaces the previous country guidance cases. So you've got the older cases of FS and SZ and JM. And then at paragraph 3, the tribunal say decision makers should begin by determining whether the claimant has demonstrated that it is reasonably likely, that's the relevant standard of proof, that he or she is a Christian. So the first issue that you need to look at if you're running a Iranian asylum conversion case, or in fact any sort of conversion case, is the genuineness of somebody's conversion. Now, a really helpful decision, which you might want to go back to and revisit, is a decision from the Scottish Court of Session in a house. It's called TF and MA, and the citation is 2018 CSIH 58, and it's a decision of the 30th of August 2018, and that particularly looks at the weight to be given and the approach to evidence from church leaders and church members in relation to somebody's conversion. So if somebody's established that they are a genuine Christian convert, the upper tribunal go on in PS to say the following considerations apply. Firstly, a convert to Christianity seeking to openly practice that faith in Iran would face a real risk of persecution. So if you're a genuine Christian and you would want to practice your faith in the open, that would lead to a real risk of persecution. There doesn't need to be additional elements such as proselytizing, as has been in previous decisions. Secondly, if the claimant would in fact conceal his faith, decision makers should consider why. If any part of the claimant's motivation is a fear of such persecution, the appeal should be allowed. So if you're going to be discreet about your faith, if one of the reasons, even if there may be many reasons why you're discreet, if one of the reasons is because you fear persecution, then you should still be successful in your asylum claim. Thirdly, if a claimant would choose to conceal his faith purely for other reasons, then the protection claim should be refused. And the upper tribunals say the evidence demonstrates that it is possible to practice your faith in a private and solitary manner within the confines of your own home. The upper tribunal go on to look at the issue of what happens if somebody is insincere about their faith and not genuine. Well, that wouldn't entail a risk in their home country, but decision makers must consider the pinch point of return. And people will be familiar with that phrase from the previous case, AB, which dealt with Iranians and internet activity. So it's the upper tribunals say that all asylum seekers returning to Iran are subject to questioning on return about why they claimed asylum. If you divulge that you claim to be a Christian, you're likely to be transferred for further questioning, but you're probably going to have to sign an undertaking to renounce your faith, and that questioning will be generally short and will not entail a risk. Remember, here we're dealing with those who are found not to be genuine. But if for any reason the detention could become prolonged, the risk increases. And those issues will have to be looked at on a case-by-case basis. What could make the risk prolonged? Previous adverse contact with the Iranian security services. If you're a person of interest to the Iranian authorities. If you've been attending a church, perhaps in the UK, with a link to the Iranian house church movement. Or if you've got overt social media activity promoting actively Christianity. So if you actively promoted Christianity on social media, that could lead to prolonged detention, even though you're not a genuine Christian, and put you at risk. So in summary, the key issues to look at is, are you a genuine convert? If you're a genuine convert, you're at risk. If you're going to be discreet, why would you be discreet? And thirdly, is there a risk even though you're not a genuine convert? Now, the Home Office have responded and they've issued some guidance called Christians and Christian Converts, version 6, published in February 2020. I've looked at pages 7 and following, which is their summary of risk to Christian converts. And it's a bit of a mishmash. They tried to hold their position, which was rejected in this case, but then summarize the effect of PS. And when you're appearing before a tribunal or you're making representations, PS is the current country guidance, and that is the correct approach to be followed. I hope this video was helpful. Thanks.